Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, I'm Matthew Hall, and thank you for joining this episode of Our Curious Amalgam, looking at trends and developments in Latin American antitrust. LATAM includes a number of important jurisdictions from an antitrust or competition law point of view. It's, of course, a very varied area, but at the same time, many countries within it continue to undergo significant economic, political, and social change. This impacts the ongoing development of competition law, which has been fairly stable recently, but now in particular, as in many other jurisdictions worldwide, there are often demands for a more flexible or tailored approach to the law and its enforcement, beyond the traditional focus on the consumer welfare standard. We will discuss today how these issues in LATAM are impacting antitrust and its enforcement, particularly in the most important jurisdictions, or what are sometimes called the Big Six, of Brazil, Mexico, Chile, Colombia, Peru, and Argentina. My co-host today is Anant Raut. Who is our guest today?
Our guest today is Julián Peña. Julián is the head of the competition law practice of Allende Brea in Argentina, and he's a professor at the Universidad Torquato de Tella's Masters on Law and Economics. Welcome, Julián.
Thank you. Hi, how are you?
Good. Well, why don't we start with how we're framing this discussion? Can we really talk about Latin America in broad strokes? I mean, is it a little like trying to describe American food? Is it too broad of a category, or are there some common themes?
Yes and no. It is true that Latin America covers countries as big as Brazil and as small as Honduras, but it is also true that there are many common patterns that you will see in Latin America. You have a same cultural history, same economic history, same political patterns that reflect a reality that it is true for most Latin American countries. We have to remember that from Mexico to Tierra del Fuego, we have all been former Spanish colonies, and that it has a direct impact, except Brazil, who was a Portuguese colony, and that has also some differences, but sure. Not substantial. There are differences between Brazil and the rest, but there are several common patterns if you look at deep in what drives both the economy and the politics of Latin American countries.
And I think that's a good place for us to start. Why don't we provide our listeners with a little bit of context as to what some of these common themes that you've noticed recently?
Well, just to show an example, in 14 of the last 15 presidential elections in Latin America, there has been a candidate that from the opposition that has won. So that shows that in Latin America there is a big discontent with both the economy and with democracy. And it's also, this is true because if there's a region that has been hit the most by the COVID crisis, has definitely been Latin America. And that has generated high levels of fragmentation and polarization in the societies. And that has left different countries with a completely new scenario with great uncertainty on how it will evolve both economically, politically, and socially in the next few years.
Julián, what kinds of common themes are you seeing with respect to competition law in the region?
Well, in competition law in particular, we definitely have a common history and a common present as well. The common history comes from as we have shared with most Latin American countries, a same paradigm of intervention of the state in the markets, and it has shifted in 20 years ago, and we have since then seen a great consolidation of competition law in the region. However,
and let me just interrupt you right there. And when you say consolidation, what you're talking about is kind of a uniform approach. Is that what you mean?
Not necessarily. Consolidation means that competition law has not been something that started in Latin America because of a desire from Latin American countries to have competition law. This is something that was a condition that was imposed in order to get financial relief in the 90s.
What are some examples of this consolidation that you're talking about?
Even though there have been substantial changes in the region with regard to the different governments, no competition authority has been replaced by any of the new governments. There's an example, for instance, in Mexico, where the president of COFECE lasted her 3 years that were remaining as president, with a president that was of Mexico that was not the one who appointed her. In Brazil, the fact that the new president of CADE has been previously appointed by different from presidents of different parties in the past as superintendent of CADE, and vice versa. The new superintendent of CADE of the Bolsonaro government has been appointed, although he was the president of CADE during the opposition's government. And the second example of consolidation is the fact that there has been a huge growth in the antitrust community in Latin America, and that didn't exist 20 years ago, and that is something that is reflected in the amount of and the quality of economists and lawyers from the public, private, and academic sectors that exist in Latin America nowadays, and which are an essential instrument in order to have a successful competition law enforcement.
So what I find fascinating about what you're telling us is that antitrust and competition were almost imposed on the region as a condition of these loans, which is very different from, I think, the preconceptions and approaches maybe in the Western countries of this is an ideology that we need to export to the world. They will naturally come to it. But this was imposed, yet it has taken hold, it has taken root. But now what are you seeing? We are seeing some differences, some evolution of that thought. And in fact, I think that you coined a term in one of your recent articles, flexibilization. Can you tell us a little bit more about what you mean by that?
Well, the flexibilization has come from different, in a certain way, when you import a remedy that has been designed for a different context, you find certain resistance in order to, and that is something that has been going on in most Latin American countries since the beginning, and but this has been aggravated by two factors. One is the increased political demands to take measures for facing the crisis of COVID, and what is interesting here is that you will not find perhaps many. You will not find agencies issuing decisions that have flexibilized the case law, the way they have interpreted the law. but in a certain way, what you will not find also is, and that doesn't mean that they didn't exist, any sanction for any kind of agreement among competitors during the COVID crisis. In a certain way, they didn't impose fines for crossing the red light. They just turned off the light. Or looked the other way. So that is a way of flexibilizing the competition law enforcement. And you will see, for instance, that last 2 weeks ago, there was the OECD released a report on the evolution of competition law in Latin America in the past 5 years, and you will see a reduction of cartel fines and also in the past 3 or 4 years, and which coincide with the COVID crisis, and also the fact that in the merger cases, where there have been more merger filings, there has been less decisions with ordering divestments or rejecting the transaction. So you see a flexibilization on by omission, perhaps, rather than by issuing resolutions that justify the existence of crisis cartels.
Julián, that's very interesting. Those are interesting examples of flexibilization. I was just wondering if there are any other particular examples you would point to. You mentioned in particular mergers and COVID. Do we see, for example, more kind of general public interest type input coming into antitrust?
Definitely, and this is a crucial issue, which is in a certain way, if we can say that if there is a crisis in the Vatican about the existence of Jesus, imagine if we among those who were not original believers, like the fact that in the United States we are discussing the fact that what competition law should be about has been has opened a Pandora box in Latin America, because it has led to politicians to say, well, don't be more popist than the Pope. If in the United States they are flexible with regard to what competition law is about, we should not be more radical than the United States and be so rigid with regard to our interpretation. And that's where you find in recent years something that didn't exist before. Public interest concerns in cases about labor issues in Mexico, in Colombia, and Brazil. You have even had a case in Argentina where there was an import substitution issue that has been used as an excuse in order to issue a decision by the Antitrust Commission. And
Julián, let me probe that a little bit further, because I think that in the United States, for example, supporters of the new approach would say that this is not a change in antitrust law or anything all that radical. These are always powers that the agencies had. These are always issues that the agencies should have been concerned about, labor being a great example, where you don't have to change the law, but there is sufficient flexibility within the laws that exist to prioritize maybe things that hadn't previously been prioritized. Are you seeing a departure from the practice of antitrust law and competition law in the region, or are you seeing just a different prioritization of what are still traditional competition issues?
I think it's both. I think that in one way, the fact that, as I said, and I've heard antitrust authorities from the region say that, well, if the goals of antitrust are being debated again in the United States, that means that we can debate them as well, and in fact, for instance, in Argentina, the draft merger guidelines that has been released this year by the Argentine Commission, and which were commented by the AUS as well in regard to this issue in particular. They pointed out the fact that you should defend yourself on in merger cases and on issues of, for instance, gender or labor or environment or whatever you think is compatible. So basically, it is converting. It has, and this is something they said we're doing because the U.S. is doing it. There's another semantic issue that perhaps shows the difference between what is going on in the United States and how it is reflected in Latin America, or at least in some Latin American countries. The fact that, for instance, we use, and that is true for all Latin countries, Latin languages, we use one word, which is política, for two different words in English, which are politics and policy. So basically, if you mix the vagueness of the translation, or the ambiguity of the translation of the word politics, política and defensa de la competencia, as I said before, basically is you can do whatever you want. And I'm now taking you out of the big six countries. There was a few years ago, there was a draft bill issued by the Venezuelan government that said on competition law, it was and they said that the reform of the competition law was crucial for the consolidation of the socialism of the 21st century. So basically, this ambiguity has led to redefine what the governments think the competition law should look like. And I'll give you a very recent example. Both, and this is justified in the fact that you don't need to change the law. The laws are in fact, very broad and with regard to what the goal of the law is. So you need to go to Congress to change the interpretation. And I'll give you a recent example. The last week alone in Brazil, there was the president of CADE issued a resolution asking the superintendent of CADE to investigate the potential collusion among the pollsters in the presidential election of earlier this month, because they all had it wrong. But if you see the presidential elections everywhere, the polls do not reflect necessarily what people actually turn out voting. But the fact that CADE has issued this decision and made it public shows that it has flexibilized what competition law should be about.
Julián, you've made reference to LATAM competition law looking to other countries. You mentioned the US, and I think it's maybe we have to cover, I think, the question of how competition law has been looking at the digital economy. Clearly, in the US and the EU and many other jurisdictions around the world, this is probably the issue of the moment. How has if it's possible to say broadly, how have LATAM competition agencies taken on digital economy, platform, data issues?
Definitely, the situation in Latin America is very different from the one in the US and in Europe. We don't have to underestimate the influence of Europe and also in Latin America. But there are reasons that to explain why it has not been not even close to what the issue is in the United States or in Europe. The fact that first the first reason is that, as I said before, the economic, political, and social situation has not been been generated by the big techs. It has been it has led to other political and social interests with regard to what should be done with public resources. Second, the fact that none of the Latin American countries are going to be the leaders on this. They are closely following the what is going on in other jurisdictions, but you will not find in Latin American countries that they will lead the way with regard to digital economy, and that has been reflected on the fact that you will find, for instance, in Mexico, they created a special body to follow the digital economy, but you will not find any substantial measures. Perhaps there have been some sporadic issues, but in those are just the exception, and they're following what is going on in other jurisdictions.
Is maybe a reason for that some of the players are different? There's less concentration, more competition, or is it the same players and they're just taking a different approach at this stage? Do you foresee it changing as we move forward?
I think that the players are the same. They're not Latin Americans, basically, but although Latin America has created some unicorns that were still far away from even thinking about the possibility remote of having a big tech company, and so the players are global, and those are not. That is not only. That is not the issue. I think that it is first. In order to investigate and to do something about digital economy, you need to understand it, and you need a budget in order to in order to have the resources, the technological and human resources. And another thing that shows this OECD report is that the budgets and the human resources in Latin American jurisdictions in the past 5 years has been almost the same. So there has not been much change, and definitely the Latin American agencies are under-resourced in order to even think about the possibility of taking measures about such a complex economy.
As you say, they have to pick their battles, don't they? They don't have unlimited budgets, and these are hard cases.
That is not the case.
These are hard cases to run and win, even for the European Commission. So
Yes. And another thing that shows the report is the resources of the Latin American agencies vis-a-vis the average resources of the OECD countries. The difference is huge, and
not to mention the companies themselves. They're probably trying to fight companies themselves that have a bigger budget than them.
Data privacy is, for instance, not it's not an issue. They prefer if you have less resources, you prefer to have something for free than although it's giving out data that it is not a social concern, and if it's not a social concern, it is not a political concern. If it's not a political concern, then it is more difficult to justify an agency intervention.
Julián, obviously what you've talked about today with these trends and, as you put it, flexibilization have tremendous significance for practitioners in Latin American countries. For our listeners in other jurisdictions, and bearing in mind that our listeners run the range from private sector purists to staunch advocates for antitrust reform, what should they take away from all of this?
I think the most important takeaway is the fact that you do not have to underestimate the impact of culture in competition enforcement. I think that the devil is not in the detail. The devil is in the culture, and having the laws that look similar doesn't mean that they're enforced in a similar manner, and that is definitely an example that Latin American countries have expressed, and there is no one size fits all kind of solution for competition enforcement, and there will not be a homogeneous competition law enforcement because we are culturally very different, and it can be misleading to think that because things look similar or the same, they are even similar or and that is something that is a takeaway that I remember once discussing this with general counsel from a Japanese company. Said, well, I rely on the fact that I feel comfortable on the fact that other countries have the same model laws, and so don't I think that each jurisdiction has its own peculiarities, and those have to be taken into consideration.
As you say, Julián, the laws are the same up to a point, aren't they? Even if they look the same on the page. That's been a really great discussion. We've from the history of antitrust in Latin America through your flexibilization concept and now the takeaways. So thank you very much for that. It's been very interesting. We'd like to move to the final section of our podcast, please. We're going to try to get some information about you for our listeners. We always ask our guests, could you please tell us something interesting or unusual about yourself which we wouldn't know if we only worked with you professionally?
Well, one thing that I dedicate a lot is the fact that I'm the father of 5 children, and that is trust me, it's something that takes a lot of time and energy, and I love that, and I try to spend as much time as possible with them, even though because of my work I have to travel a lot. But I, at least on the weekends, I try to be back home in order to enjoy them while they're at home, because I know that life goes on, and sooner or later they will each have their own life. But in the meantime, I'm enjoying chaos as a part of life.
enjoying the chaos. That's a kind of oxymoron, but that's amazing. That's really interesting.
And now it's time for the Curious Hat.
We have our final section where we ask you to pick a number, please, Julián, between 1 and 13. This is our Curious Hat segment. And we ask you to pick a number, and then we give you the question which relates to that number.
Okay, I'll choose number 5.
All right, number 5. Julián, are you a cat person or a dog person or neither, and why?
I thought I was neither, but now since the pandemic, we have a Jack Russell, and I have become a dog person. Although I have questions from my sons in order to also to be flexible and to have cats, but
I think there's no wrong answer to be cat or dog. Fish people, I'm a little leery of, but cat or dog, either direction, I think is fine.
No, definitely. We had a fish, but it was boring. Trust me.
It's like a lava lamp. Like, what's the point? Exactly.
But we enjoy having the dog. Perhaps in the future we'll have a cat, but that is to be seen.
Thank you, Julián, for coming on. Again, that's been an incredibly interesting run through of what's going on. And we'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.